Hi there, this is Anais Smith. Welcome to my channel on family law and mediation and related topics. So today I want to talk about the topic called forfeiture. So forfeiture comes into play where one party feels aggrieved and they are of the opinion that if the other party gets a full half share of the estate, that it will be unfair. So when you ask the court for forfeiture, court will consider three factors. So the first one is the duration of the marriage. So this comes into play where you have two situations. So the one you will have the rich old guy that marries this young chick, and they married for 12 months, and then she decides now there's some other old guy that she likes more, or he realizes, oh my goodness, she's just spending all his money. So she will not be entitled to half of his estate because obviously she hasn't contributed much, and the marriage was only for 12 months. Then you get another situation where the couple has been married for 25 years or longer. They had a whole life together with the family. The wife might have not worked the full period due to the fact that she was looking after the children. So if that husband, for example, asks for forfeiture of the assets, that won't be applicable in the situation because obviously she has contributed in the sense that she has looked after the children and that she played a vital role in the upbringing and contributing towards the household. Then the court will look at the circumstances which gave rise to the breakdown. So fault is not necessarily applicable anymore. So to say that somebody just left the household or they committed adultery is not really sufficient. So the court will consider that, but it won't necessarily play a role to determine whether there is forfeiture or not. Then there is the aspect of substantial misconduct on the part of either party. So misconduct will be cases where one of the parties are gambling excessively or drinking all the household income out, where one of the parties sell assets that they're not supposed to. That is misconduct. So I want to refer specifically to a judgment of 2015 as an example in the matter of Ramaroka versus Ramaroka. So what happened here is the husband and wife were married for about 13 years prior to instituting the proceedings. And then the husband, who is the plaintiff, wanted a divorce, and the wife, who is the defendant, put in a counterclaim for forfeiture of her share of his share of the pension fund. So what would normally happen with marriages in community of property, everything will be shared equally 50-50. But what happened in this scenario that the court dealt with was that the parties had multiple assets. So they had a Mazda, trucks, 25 cows, 12 sheep, 7 goats, and 2 taxis. So what the plaintiff did is he went and he sold the assets without the consent of the defendant. So he sold the Mazda, the trucks, the cows, the sheep, not all of them, and some of the goats. Um, so his taxis also crashed, and then the insurance didn't want to pay out for that. And then what happened is the wife had to support them. So prior to all of this happening, when they initially got married, she was home for about 5 years, during which time he used the money that he got from his taxi business to pay for her studies. So then she studied and she became a nurse. And then after the taxi business collapsed, she became the sole breadwinner. So she looked after the family, she looked after him, she carried all the expenses, and she also contributed towards building a house, obtaining loans and all of that to build the house. So the court had considered all these circumstances, and then the court decided that based on this, that the plaintiff will only be entitled to 40% of the defendant's pension fund as opposed to 50%. Um, I don't know how fair this was, considering all the assets that have been sold prior to the proceedings. So I think the court would have had to make a calculation of the assets, the value of the assets, and then also the value of the studies. So I think from a practical point of view, that might have been a more favorable outcome, having considered what assets, the value of the assets that he actually disposed of during this marriage. So, having considered all of that, I think it's very important that when you decide to get a divorce and you want either somebody wants to ask the court for forfeiture of your share or you would like forfeiture, it is important that you actually go and seek the help of a specialist in the area of divorces. Because if the parties are not properly prepared and they don't have sufficient experience, it might be to your detriment in the sense that you might lose what you're entitled to, or that you might end up giving away much more than what the other party is entitled to. That is me for today. Until next time.